The indictment doesn't specify that because the law does not so require. In my remarks, I mentioned a couple of laws, which I will highlight again now. The first is New York State election law, which makes it a crime to conspire to promote a candidacy by unlawful means. I further indicated a number of unlawful means, including more additional false statements, including statements that were planned to be made to tax authorities. I also noted the federal election law cap on contribution limits. I'm not going to go into our deliberative process on what was brought. The charges that were brought were the ones that were brought. The evidence in the law is the basis for those decisions.
Ahead of the indictment today being brought against former President Donald Trump, we had it on pretty good authority. Everybody had pretty well surmised that there were going to be multiple charges related to falsified business records. But we all learned in crash course cable TV law school that in addition to those charges, there needed to be something that made those charges into a felony. On their own terms, those things would just be misdemeanors. Those things would not likely, therefore, result in Donald Trump being indicted. If he was going to be indicted, those falsified business records would have to be linked to the attempt to commit or conceal some other crime. Today, we found out what the other crimes would be, except those crimes aren't charged today. We saw Alvin Bragg just run through them briefly in his remarks when he was answering questions today from reporters. He said under New York State election law, it's a crime to conspire to promote a candidacy by unlawful means. He described additional false business records charges, not the ones that were charged against Trump today, but additional false business records that were allegedly carried out by the company that owns the National Enquirer. He also described federal election law caps on contributions. Again, those were not charged today, but he cited those crimes as being essentially the aggravating factor that made the charges against Trump today into felonies. How does that work if those crimes he described today were not actually themselves charged? I put this question to two of our legal experts who are here with us today, Catherine Christian and Andrew Weissman, both of them veteran prosecutors who've seen this both from a federal and a state perspective. Can either of you walk through us non-lawyers, through this part of these charges?
You want me to take a crack?
You go ahead.
Okay. So the first thing to know is that the statute in New York that says you can bump this up to a felony requires that you have an intent to commit some other crime. You don't actually have to commit that crime. So that's why you wouldn't necessarily need to charge it, and that's something that Alvin Bragg said. Also, if one of the crimes that you're thinking can be used as that bump up is a federal crime, then that is not something that you could charge in state court anyway. Now, this really goes to Chris's question in the last segment, where he sort of said, isn't this really still a tenuous case? Isn't there a problem? Because this is really a legal issue in this case more than a factual issue. And this is where I actually was impressed in terms of what was charged here, because there's so many different ways in which the DA has laid out how he can get to a felony. He has suggested in his oral remarks that one way is the federal campaign laws. Another way is the state campaign laws. A third way is he talked about AMI issuing false statements, and this was in furtherance of those false statements. And a fourth way was tax charges, exactly what you had laid out, Rachel, in terms of the scheme to have Michael Cohen commit tax fraud. Which, by the way, is exactly the kind of thing that was alleged in the Trump Organization Weisselberg case that just resulted in convictions in November. So those give the DA a lot of room. So even if there's an attack on one or two of them, particularly the state crimes of tax fraud and the AMI false statement charge seem very solid. It seems very hard to imagine a motion to dismiss that's going to knock out all of that and reduce all of the charges to misdemeanors.
And it doesn't mean that when you describe, Andrew, the district attorney as having laid out a lot of different paths by which he can get to a felony, sometimes, like, when you see that in a movie script or something, you think, oh, they've given you a whole bunch of different options because they don't have one good, strong one. But in this case, you're saying that's not a sign of weakness, that's a sign of strength of the case, because even if one of them gets knocked out, they've still got other viable means.
Yeah, absolutely. That when I would charge, and I'm sure when Catherine charged, you know, if you have a really weak one, you don't want to do that and have it sort of taint all of the other ones. But if you have like 4 really good options, lay them all out. The defense is entitled to make motions, and you never know what a judge is going to do. That's the reason you lay out your strongest ones. And here, there are just too many options that I'm sure when the defense looked at this, they were actually thinking this is more than we had sort of bargained for.
Catherine, let me just ask you to expand on what Andrew has said there, especially his point about how you don't necessarily have to charge the crime that would bump this up to a felony. You just have to show that there was an intent to commit that crime, whether or not it was in fact committed, whether or not it is in fact charged. Again, that's for those of us who aren't lawyers, that can be a little bit hard to wrap your head around. If there's an intent to commit a crime or an effort to commit a crime, why isn't that charged behavior?
Yeah, well, as D.A. Bragg just said, you know, we didn't charge it because the law doesn't require us to do it. The statute reads, people also always forget, you still also have to prove the intent to defraud and then the intent to commit or conceal another crime. So as Andrew said, it doesn't say that you intend to defraud and you committed another crime. So, and Andrew is right. The New York State election law, the federal campaign law, if that was all it was based on, then it really makes it a really difficult case. But the tax fraud and the AMI false statements, that makes it I'm not going to say a rock-solid case, but you can understand why this case was presented and why the DA's office believes they have proof beyond a reasonable doubt. And because the jury can believe, okay, forget the New York State election law, but tax fraud and those false statements by AMI.
And on the tax fraud issue, again, what they said today was Michael Cohen paid Stormy Daniels $130,000. He got paid back way more than that because they put a whole bunch of other stuff on it. But one of the reasons they plussed him up and gave him lots more money back, not just a straight $130,000 reimbursement, is because they wanted him to net out $130,000 after this was put on his income taxes as income. Do they actually have to prove that he did book it that way with tax authorities, that he did actually claim it as income falsely on his tax returns in order to get there? Or do they just have to show that that was the rationale for why they structured the payment the way they did, whether or not he eventually submitted false paperwork to the tax authorities?
Andrew wrote on this, so I'm going to let him take the lead.
Okay.
So the answer is that you don't have to show that it actually happened. Imagine, for instance, Rachel, if Michael Cohen was arrested in the middle of the scheme. You wouldn't be able to say, okay, I had this intent to do it, but because I didn't actually carry it out, I can't be sort of charged with a felony if they can show that you had that intent. Of course, if you actually did it, that's going to be very good proof that you had the intent to do it, but it's not actually necessary. And in this case, there actually is reason to think that, for instance, the Trump organization and Donald Trump himself might have wanted to deduct the, quote, legal fees as expenses, but, right, and so that would be tax fraud, but there's a reason to think that he didn't do that because he became the president. And there was a lot of things that weren't done at that point, as was shown in the Trump organization trial this past fall, where basically the accountants turned to them and said, you know what, we're going to be under a lot more scrutiny, so the stuff that we've been doing, well, let's just stop for now.
Ari, I feel like we talked early on about how the falsified documents part of this is something you can put on TV in one full screen image, and you can see all the false documents and you know that they're false. That's very easy to understand. Getting that explanation from Catherine and Andrew makes me feel like, okay, the other part of this, why is this a felony? What are the other crimes this is connected to? That feels very explicable, very straightforward now, too. How do you feel about the overall strength of this case?
I would call it medium high, not completely high. A prosecutor would like more precedent. You'd like more precedent on the books. But then again,
meaning just more cases like this that have previously been prosecuted.
More cases like this, I think, would just be generally helpful. Prosecutors like that. But Donald Trump, we should all remember, is fairly unprecedented. These type of schemes are not habitually pursued, so that is what it is. The other point that I think is great about the news, we love learning new things. We know a lot more tonight than we knew last night. Now we know, based on this theory of the case, why they didn't charge a conspiracy. Because while a conspiracy sounds big and bad, it, as our veterans there just explained, our prosecutors, raises the number of things you have to prove. And now we may know why Mr. Pomerantz and others who were under the previous DA's leadership there, under Vance, and had an initial clash with the current DA, Bragg, why they were so unhappy. They were doing a big swing and big stuff. And Mr. Pomerantz's book says that. We've had him on MSNBC. He didn't win the day on that. What we have here, and this is why I'm medium high, not medium low, is what we might call a winnable, moderate style case. It does not throw the entire kitchen sink of everything Donald Trump might have done in New York. It doesn't even deeply pull in the indicted Trump organization, which some lawyers would be tempted to try, but with the CFO, Weisselberg, not testifying against him and available as a defense witness to say, yeah, everything at Trump Org happened without Trump. You know how Trump Org is. We went rogue. Well, that's not a thing they really wanted to do. So they didn't do conspiracy. They didn't do a ton of Trump Org. And as our prosecutors remind us, they did this phrase. I mean, I highlighted it the moment we got this news today, tax purposes, right? And you mentioned it earlier, Rachel. There's a lot of evidence all around Donald Trump that they habitually intend to lie. The fact that sometimes those lies don't reach the governing tax authority may not bail them out or be all that sympathetic a sounding argument to a New York jury.
Right, and in this case, the intent to essentially make false representations to tax authorities was apparently annotated in a handwritten notation by the Trump Organization CFO, written on a bank statement that they have.
Well,
and you taking notes on a criminal conspiracy? Sorry.
That's how we do it in Trump Org. Two things. One thing Andrew Weissman said in the earlier hour, which is, we may not want to just suggest that the broader investigation into the Trump Organization is over. First of all, the DA has suggested it's not over.
Sure.
Right.
Second of all, the timing on this is curious, right? December. Could it be that they're buying themselves enough time to get the rest of the case, the broader case against Trump Org, in line? Alan Weisselberg, who is really the linchpin to all of this, gets out of Rikers 2 weeks from tomorrow. We know 5 days ago he retained new counsel because Trump Org was not happy with the counsel that he had thus far, Nicholas Gravanti. He is now being represented by a different Trump paid-for lawyer, which is to say, in plain English, the lawyer that he has retained is being paid for by the Trump Organization. They are clearly worried about Weisselberg being, pressured to testify maybe in future or ongoing investigations. So I think, there's a statute of limitations piece here that I think dictates some of the timing, right, in terms of this piece of Trump's wrongdoing. But the broader fraud that may have taken place, the bigger Cy Vance, the case with its origins at Cy Vance's office, that may not be over under the stewardship of Alvin Bragg. And the great Andrew Weissman said on air that it might not be over, so I listened to him. And I think that, the key players in this are maybe not done testifying.
I think the thing that is in conflict over and over and over again, and I think Alvin Bragg made 2 points that stuck in my head and inform how we cover this moving forward. One, we bring cases like this all the time. But to your point, Trump is such a different animal. He is both corrupt and cheap. And so when you read through this, you see those things clashing, right?
Yeah.
You see AMI doing these corrupt things. You hear Trump saying, wait it out. And of course, Melania is still going to be alive. So of course, Joe Tacopina sounds like a clown with that defense. But these things are in constant, violent contradiction, that he's so cheap. I'm not paying any more hush money than he's got to. Oh, but he really needs to cheat to win. I mean, these two things in the Trump story.
He makes his lawyer take out a home equity line of credit in order to pay the hush money.
It's so cheap. So it's this cheap cheesiness that's embodied by how he's doing it, and it's his brazen corruption that Mary McCord made this statement that just sort of haunts me, that Alvin Bragg's framing is this broad and violent assault on our democracy, this fraud carried out. You know, I worked on campaigns. August 15th, before an election, to November, is sort of this sacred space. It's why they don't bring charges against candidates, because it's sort of this safe space. But it's when Trump was getting down and dirty.
Yeah.
It's when he rolled in his National Enquirer bros. It's when he has Cohen take out his cheesy home equity loan. It's the crime Rudy confessed to on Sean Hannity. I mean, it's all so tawdry. It may be exactly why Merrick Garland and Lisa Monaco said, ew.
Yeah.
But it is so brazenly and plainly criminal that it makes sense to even the non-lawyers.
The noblest experiments in human governance can be brought down by the stupidest, tawdriest, most embarrassing things of all.
That.
Children. All right, we'll be right back. Stay with us. More to come.